Hi, my name is Andrew Kinney. I do Social Security work as an attorney. I've done this work for 20 years. I focus on just this work. This is a classroom setting for Social Security Disability 301. It's sort of an upper level course. Not that I know all that, but the idea is I'm trying to structure information in videos for people that are different understandings of how Social Security works. Not many people do understand how it works. It doesn't make me better. It just, Social Security is difficult to understand. I can tell you, having seen federal courts, particularly district courts, they don't understand Social Security. There may be ego. I'm going to stop right there. But whatever reason they don't understand it, hopefully this video series helps, because this is litigation, and this is at times more difficult litigation because we are compressing someone's whole medical life, which can be complicated, into 1 hour. So if you think of all that backdrop, there are certain skills attorneys need. We've gone through research skills, analysis, medical vocation, and vocational analysis, argument, both written and oral, all right? You can do things any way you want, but the question is what are effective skills, not just things that are good to do. What's an effective, and the most effective way you can do your work as a Social Security attorney is to get the judge to look at the fundamental issues. You'll know if you've gotten to that point where cases are balanced one way or the other, where a judge may not have thought there was a case. That's when you're doing your job. You're going into where the medical evidence leaves off and the judge's decisions lead in. You're trying to identify that point in hearings. So we've moved all the way down from the last presentation on listening. We're going to go to questioning. You need to question what you understand about the case. Questioning is sort of a broad skill, but you need to question what you understand in research. You need to question what you actually know about your client, not just gender, where they live, their address, their phone number. You need to question what is really wrong with them, what do they think is wrong with them, which is sometimes different. How do you think they're limited based on the medical records? How do they believe they're limited? Because that has an impact on how they answer questions from the judge. What do they understand about their limitations? Let's say it's depression or anxiety. How do they feel about being depressed or anxious? They may be embarrassed. They may accept it. They may be overwhelmed by it. You need to question your client before the hearing about these things to understand where your client is coming from. We're trying to argue that your client cannot work full-time work, and you have a theory of the case, but you need to question first before the hearing your client. Does why you think your client can't work match at all with what your client thinks they can and can't do? If there's a disconnect, you may need to adjust your theory of the case or adjust your client's understanding of their disability. And unfortunately, we don't have the luxury of time. We wait a year and then we know what judge we have. The judges are different, and then we have to respond. The questions that you ask your client before the hearing then should inform how you do your opening argument, or perhaps even written argument for the hearing. The questions the judge may ask you before a hearing or during a hearing even, those questions tell you a lot. When you listen to them, the questions, for instance, why you're asking these questions of your client, counsel, you need to know why you're asking questions of your client when it's your turn. And if you're interrupted, you should be able to know why you're asking things. Having an agenda is a negative thing. It sounds political, like your agenda is you're trying to push someone some way by manipulating them. Social Security hearing is a little different. You need to have your theory of the case. You need an agenda. Everyone knows why you're there. You're not there to tell your client they can work. You're explaining why they can't. The agenda is built in, but the problem is you need to identify what your agenda is specifically, not generally. Your Honor, my client can't work. That's why we're here. Your Honor, my client can't work because of back problems. Yeah, I saw that. They can't work because they have an MRI that shows they have back problems. Yeah, they may know that. What does the MRI show? When did it show it? What problems did they have before and after? Are there any interesting intricacies or interactions in the medical record from beginning to end? Are there doctors that don't diagnose something, a later doctor diagnoses something earlier? There's a medical record, flow of the medical record in terms of research. If your attorney relies on other people to summarize a medical record so the attorney can just read off diagnoses, get another attorney. Your attorney needs to do research of your record and understand your medical record, not just have someone summarize it. The old school attorneys would have medical records summarized, and it's not a bad thing to have someone help an attorney summarize it, but the attorney should not rely on someone else's summary. Your ability to ask good questions of your client before and during the hearing can really make a difference if you understand the medical record and have done your research. You may ask your client, why did this neurologist say that you could work? And the only way you know the answer to that is because you did your research and you analyzed the medical evidence and realized that perhaps that doctor didn't have an MRI that was available. And that's actually happened in hearings. When the judge is questioning you on why you're asking questions, that's basically the best cue you can have that the judge is not following why you're asking questions. Your theory of the case isn't helped out by anything you're doing. If you're doing something that isn't helping the judge understand your client better, then don't do it. Your questions of the medical experts in the form of cross-examination are getting, as I mentioned in the previous video, getting toward what? They're getting toward a point where maybe there is a question about how strong or weak the medical evidence is. Well, at least if you punch toward that uncertainty and say, is it possible that my client have chronic pain? Is it possible that there can be intermittent nerve radiculopathy? Is it possible that? If you get to that possibility, and if that's all you can expect from the medical expert, your questions are getting to where the judge leads from what the objective medical evidence says to credibility. Your questions need to make your client credible. If your client complains of things, and with your questions the client says it hurts, it hurts, it hurts, but the medical expert says there's no objective evidence that it should hurt, you question the medical expert about, is the diagnosis valid? Was a surgery needed? And you have in the medical evidence different excerpts. Was there any time, doctor, the medical expert at the hearing, that your client was refused pain medications? If in fact you indicated, doctor, that there's lacking medical support for this diagnosis. This is an example of a cross-examination question. Doctor, if there's lack of support for medical diagnosis, why in fact are they prescribing controlled substances for pain? Doctor, is there any evidence in the record that a doctor has refused pain medication because the diagnosis was lacking? Let's say it's fibromyalgia. Is there any evidence, doctor, that someone questioned, in this case fibromyalgia, whether there was adequate support for fibromyalgia diagnosis? Doctor, what are the criteria for fibromyalgia diagnosis? In this sort of questions, you're getting at one thing. If a doctor doesn't believe, in this example, that fibromyalgia exists, your questions are at least getting to that. If the doctor doesn't believe fibromyalgia exists, it has nothing to do with the client. It has everything to do with the doctor's testimony. Your questions for those experts and your client, but the experts in particular, are going to get at a broader question. Not whether your client can work or not, but whether the doctor is ever going to believe or accept medical diagnoses. I've literally had a doctor or a psychologist in a hearing years ago say he thought there was no such thing as a personality disorder. As it turns out, it's probably why he didn't want to acknowledge he had his own. But if you think about this, those sort of questions, you need to get two questions because you're listening and asking the questions that the judge may be thinking of. Your goal is to ask questions that the judge would have asked. If you do, you're in line with the judge because the judge makes the final decision in your case. So this is the end of Social Security Disability 301, discussion of skills. Hopefully this helped. We round this out. My goal is to have a 401 on particular medical problems and go through different ways Social Security handles these things. Thank you very much.